I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about the National Council for Adoption v. Blinken. This is a case from the D.C. Circuit Court of Appeals in 2021. And the case addresses the question of some rules from a federal agency and whether those were legislative type rules that needed to go through notice and comment rulemaking under the Administrative Procedure Act, or they are interpretive rules from the agency that are exempt from notice and comment rulemaking. So let's dive in. Our core issue here is whether Department of State guidance on what's called soft referrals for international adoptions is a rule that needed to go through notice and comment rulemaking under the Administrative Procedure Act, which this rule did not, or if it can stand as just an interpretive rule that falls under an exemption or exception in the APA. So this case really is about some website changes that the State Department had posted in 2018 that were these frequently asked question pages, or FAQs. We start in February of 2018 when the State Department posted an FAQ that said, as the court notes, in something of a postscript, that a, quote, soft referral is not an acceptable practice under the regulations and may lead to an adverse action by the State Department against the adoption agency. This sentence in the FAQ in February of 2018 sparked a lot of confusion in the adoption community, which is all of the workers and lawyers involved and agencies that handle international adoptions, because the term soft referral was unfamiliar to a lot of the readers. So people started flooding the State Department with inquiries and questions about what does this mean? What are we allowed to do or not allowed to do? So in response to this sort of flood of inquiries, a month later, in March of 2018, the State Department updated its website again with a new page entitled Adoption Notice Guidance on Soft Referrals. And it defined soft referrals as two types of practices. So according to the court, the first type of soft referral that, as the State Department defined it in this second update, was informing prospective adoptive parents about a specific child before the country of origin determined that the child was even eligible for an inter-country adoption. Sometimes they would do this without giving the individual child's name to the prospective parents, but keep in mind that international adoptions involve getting permission from both the United States government for bringing a child here and the government where the child is being adopted from, that this child can be removed from the country and given to parents somewhere else. The second type of soft referral sort of had two parts. This was matching a child to a family before the prospective parents' home study and background checks were approved. In other words, the adoption agency was supposed to visit the home and do a home study to make sure that it was an appropriate place for bringing in an adopted child, and do background checks on the parents. And the agencies were sort of trying to get going on a preliminary matchup, or at least letting the parents know that they had a child that might be a good match for them before they had completed these tasks. This category of soft referrals, according to the State Department, was even more common than the first type that we talked about, which was the preliminarily informing parents. And this type of matching involved putting a hold on the file for the child, which effectively removed the child from consideration by other families or other agencies that were doing international adoptions. A few months later, we have yet another FAQ posted on the State Department's website, and this one is called an FAQ on soft referrals, stating that providers may sometimes informally match children before completing a home study, but they cannot hold a child's file for those parents. In other words, discouraging agencies from matching the child with parents who are working with them, or the foreign governments from referring the child to prospective parents. So the National Council for Adoption sued the State Department, arguing that altogether these guidance documents that have been published or put on the department's website violated the Administrative Procedure Act, or APA, specifically the requirement of notice and comment rulemaking. The State Department said that the National Council for Adoption didn't have standing, and furthermore, that the guidance only prohibited two specific types of soft referrals: matching a potentially non-eligible child or putting a hold on a certain child in another country for parents without having completed a home study of those parents. So the key legal question in this case, NCFA v. Blinken, is whether the guidance from the State Department was a legislative rule or an interpretive rule, because that affects whether the State Department needed to go through notice and comment rulemaking, which they didn't do. And the conclusion in the case was that it was a legislative rule, that they needed to have done that. So let's talk about some definitions here, just to make this very clear for you. When we talk about a legislative rule in this type of context, for deciding whether 553 requires notice and comment rulemaking from the agency, the question is whether it has a legal effect or is issued with the intent to speak with the force of law, according to the court. And so it creates legal effects, or calls into effect potential legal liabilities and duties. An interpretive rule, in contrast, derives a proposition from an existing statute, typically, but it could also be a prior regulation that has an ambiguous provision that the agency has interpreted in various ways over the years. And the interpretive rule clarifies what it presently thinks that statute or prior regulation means, and explains the obligations and duties and liabilities and so forth. In other words, a legislative rule creates functionally new responsibilities and liabilities, or new liabilities and duties, and an interpretive rule doesn't. It says these duties and liabilities, or potential liabilities for violations, already existed. We're just announcing that we recognize that in this pre-existing text. So let's talk about the holding and the reasoning in this case. The court said that by expressly prohibiting certain types of soft referrals, the State Department had indeed intended to speak with the force of law. And furthermore, that if an adoption agency violated the guidance, it exposed an adoption agency to enforcement actions and potential loss of accreditation from the State Department to do international adoptions. And in the past, the State Department had never before announced a categorical prohibition on these two types of soft referrals. So this didn't seem like they could really plausibly say this was always the rule. This seemed to be, to the court, a new rule that was being announced. Let's talk about some of the highlights from the holding in this case. One of the quotes that I pulled out is where the court says that the Department of State never said it was clarifying or interpreting specific provisions of a treaty, statute, or regulation to justify its new provision. So it mattered to the court, and this is maybe a takeaway or something to keep in mind when you're in practice as a lawyer, that the agency was claiming that this was an interpretive rule, but when they posted the guidance, they didn't really spell out that they thought that this was their interpretation of a pre-existing rule, or that a statute or a treaty or a regulation. Another holding highlight here is that it was only on appeal that the State Department raised the best interests of the children regulations as its basis for the new guidance or the new prohibitions on soft referrals. But when the court looked at the regulation that they were citing, and again, for the first time on appeal, those regulations about the best interests of the child didn't really compel the type of categorical prohibitions that we have here. In other words, there are some scenarios the court could imagine where soft referrals might indeed be in the best interest of the child. There was also an argument raised about the regulatory context here. The State Department had argued that the overall regulatory context implied the prohibition that it had posted on its website. And these are things like the child eligibility, home study requirements, and so forth. But the court says that all of these regulations that were pre-existing really applied to the actual placement of a child in the home, not to the referrals. And the categorical prohibitions were really about these preliminary referrals of matching children to prospective adoptive parents. So the holding, in conclusion, basically said that the guidance documents, which are all of these updates to the website and so forth, were making a new law by banning two types of soft referrals, that these were not merely explaining pre-existing rules, and therefore notice and comment was necessary under the Administrative Procedure Act under Section 553. So let's talk about the outcome in this case. First, the court said that the State Department can't just treat guidance as an interpretation. They can't just make it that by calling it that and say that they're merely explaining pre-existing standards that had already required this categorical ban, because it was pretty clear to the court that there wasn't such a categorical ban in existence before this guidance. Also note that the circuit court here did not reach the counsel's substantive challenge to the guidance. So the plaintiffs had also alleged that the position of the State Department was arbitrary and capricious. And the court didn't reach that because they reversed the district court's decision and vacated the rule on procedural grounds. Let's talk about where this leaves us after this case. The casebook authors note that the court's rationale here for finding the State Department's guidance to be a legislative rule rather than an interpretive rule rests substantively on the categorical nature of the guidance. On the surface, when you read this case, it may look like the same approach we see courts taking in cases about agency rules that are masquerading as policy statements. Here, this is about an interpretive rule. And policy statements are the other type of guidance documents that we talk about in this sort of subcategory or topic of administrative law. And remember that that general approach about policy statements is that they can't be too rigid and binding, or else the court is going to say they are actually a legislative rule that needed to go through notice and comment rulemaking. But this case is not about policy statements, it's about interpretive rules. And that means that there's a pre-existing legal text that's being interpreted. And here, that's the longstanding State Department regulation that had been on the books for a while about consideration of the, quote, best interests of the children that are being adopted. And that was not categorical at all. And the purported interpretive rule interpreting that was very categorical. It carved out certain categories that would be subject to special exclusions or delay or so forth. And so the categorical approach is what the court here sees as inherently legislative and is why they needed to go through notice and comment rulemaking. Think about being a lawyer and representing a variety of clients who come to you with legal questions. Some of them want to try a new way of dealing with some of their suppliers or maybe their distributors. Some of them want to offer a new or somewhat different service to some of their customers. And the question is whether that would be violating any existing laws or regulations. So you check. You check the relevant statutes, you check the relevant regulations for that area, and you don't find anything that specifically addresses what the client is asking. In those situations, even if you're really not sure, it can be very helpful if you go to the agency's website and They have information on the website that talks about your specific scenario and how they would approach it or how they interpret the regulations. Maybe the regulations and statutes are a little bit ambiguous or unclear on this point. So they give you some guidance right away. Well, for the lawyer and for the clients, that's really valuable. On the other hand, the flip side of that is it can be very unsettling if the relevant agency can change the rules on you effectively simply by changing some of the language on their website. And that concludes our discussion of the National Council for Adoption v. Blinken. Thank you for watching.